And welcome to the Board of Administration meeting. First order of business is roll call.
Good morning. Priya Mathur.
Good morning.
Rob Fechner.
Good morning.
Margaret Brown.
Good morning.
Steve Juarez for John Chung. Good morning. Richard Costigan. Here. Richard Gillihan.
Here.
Dana Hollinger.
Here.
Henry Jones.
Excused.
David Miller.
Here.
Ramon Rubicava.
Here.
Bill Slayton.
Here.
Teresa Taylor.
Here.
And Lynn Paquin for Betty Yee.
Thank you. Next order of business is the Pledge of Allegiance, and I've asked David Miller to lead us in the pledge. Please rise. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, under God, indivisible, with liberty and justice for all. Okay, that brings us to the board president's report. So I'd like to just begin by extending my appreciation for all of the outstanding work the CalPERS team has done to help position this fund for long-term success. Whether it's reducing investment external management fees, decreasing reliance on temporary help, holding the line on new positions, or developing simpler, more efficient processes, it's your efforts that allow us to invest more toward our members' benefits and build a strong foundation for the future. So on behalf of the board, thank you for all of your dedication and the important work you do on behalf of our 1.8 million members and their families. And especially also, I want to thank the board, too, for the balanced, prudent, and deliberative decision-making over the past year that has better positioned us to protect our members' retirement security moving forward. I'd also like to acknowledge the health police journey that began more than 1 year ago, and hopefully will culminate later this morning when the board adopts a set of health beliefs statements to improve and enhance and reinforce how we manage our health program. The CalPERS team did an incredible job to make this a collaborative and inclusive effort, engaging our stakeholder groups, the board, and our executive leaders along the way. In our role as healthcare purchaser, it is important that we balance the needs and desires of our diverse stakeholders as we consider what is best for the program and its sustainability over the long term. I am proud of our team for doing just that. Thanks to their efforts, decisions made and actions taken will be aligned with the health beliefs and keep us moving in the right direction. So changing gears now, as you may recall, last month the full board authorized me as board president to create a 4-member subcommittee of the board to interview the 2 finalists for the board's independent counsel for administrative appeals and to award the contract to the winning firm. The subcommittee met on April 12, 2018, and interviewed 2 firms, Olson, Hagel & Fishburne, LLP, which was represented by Christopher W. Waddell and Richard C. Madich, and Shaw & Associates, which was represented by Shirag Shah. After discussing the 2 finalists, the subcommittee ranked the Shaw firm first and the Olson firm second. The vote was unanimous to award Shaw & Associates the contract for the board's independent counsel for administrative appeals, and the 5-year contract will begin on July 1st of 2018. Congratulations, Mr. Shaw. With that, I want to offer a reminder about CalPERS Night with the River Cats. It's going to be next month following investment committee meeting on Monday, May 14th. Gates open at 6 p.m. and the game starts about 7. I hope to see you all there. Our CalPERS Patriot Chorus will be doing a special pre-game performance, and I hope to see many of our CalPERS team members out at the ballpark for this very enjoyable event. And with that, I'll turn over to Marcy Frost.
Thank you, and good morning, President Mather and members of the board. I'm going to start this morning's report highlighting the report called A Solid Foundation for the Future. And in this report, we were able to illustrate key decisions that have been made by the staff recommendations and then the board's ultimate approval, which would include the change in December of the assumed rate of return, also known as the discount rate, and the amortization policy. I'll also brief you a bit on outreach activities as well as some internal activities that we do that really helps to support CalPERS as a destination employer. So last week we did release the report, again titled A Solid Foundation for the Future, and it paints a picture of where we stand with our funded status and outlines the actions that we have taken to ensure retirement security for California's public servants. The decisions CalPERS has made to lower the discount rate, to approve a new asset allocation, and shorten the amortization period have put us on a solid path to fund the system for generations to come. Our overriding message is that members can be certain their benefits will be there for them, just like they have been throughout our 85-year history. It is our focus and it is our primary duty to stay focused on the members' needs, the members' expectations, as well as being a reliable partner to our participating employers, also a very important part of the relationships that we have here at CalPERS. We'll use this information as a basis for future conversations, presentations, and visits with both member and stakeholder groups in the coming months. We've also made a PowerPoint template available for your use, as I know you are out talking with member groups and labor groups and employer groups, so please feel free to use that template, and if you need additional talking points, certainly let us know. We also know that pensions are a shared responsibility, and if we're going to ask our partners to contribute to the long-term success of the fund, then we need to do our part to run the system as efficiently and effectively as possible, and to invest our assets always with our 7% assumed rate of return in mind. The next 5 years will be one of focus on what we call total fund return and total fund performance. This will be done within appropriate ranges of risk parameters, but one of the things that has been, I think, very well received in some of the messages and some of the discussions I've been having with the employer partners is that these financial policy decisions were decisions that ultimately had to be made. They are the most prudent decisions, as well as meeting your fiduciary duty and our fiduciary duty for the fund. Those decisions now put us in a very good place to focus on the one piece that we have complete control over, and that is the investment side. So in yesterday's Finance and Admin Committee, you were also presented with the first reading of the proposed budget for fiscal year 2018 and 2019. It does represent a net increase of 0.3%. While some of our operational costs are growing, we've made every effort to offset them with reductions in other areas. Some of these increases are related to contracted general salary increases, and then also we expect to pay $10.5 million less in external investment management fees, and we'll also save another $3.5 million, as President Mather indicated, in personnel costs such as temporary help and benefits. And as with last year's budget, we are not requesting new PYs or new positions. In fact, we're making the most of an existing policy and protocol that we have internal called enterprise position pooling, where we really use our enterprise performance management system, both on the strategic side as well as the operational side, to look at those core processes that are operating not within the performance that we expect, so they're underperforming. As we recalibrate the organization and where the resources are needed most, that is a system that we're using to gather the data to make the best informed choices about where our resources need to be deployed. The budget also represents an important emphasis on technology solutions, and we believe that that leads to higher levels of customer satisfaction, customer engagement, and improved efficiencies. And one of the items or focus areas for technology over the next year to 2 years will be to continue to enhance our member self-service features through CalPERS. So the next step in the budget process will be a second reading and approval in our May meeting. Also, as a part of that budget, I should also mention that it does finalize the actuarial valuation system, which is the replacement of the old system that we've had here for quite some time. This is a system that's being completely developed by internal team members, which is wonderful. And so we will have that ongoing support being provided by the CalPERS information technology team. Also on Tuesday, you received the valuation reports for state and state agencies and school employers. The reports do factor in the second year of the discount rate change for the state, and then the first rate for the schools, for the first reduction for the schools, and provides information on what their contribution rates will be. Rates are going up, which we projected, and we are continuing to work with our employer partners so they understand how to put these projected rates into their own budgets and budget planning. The impact to the state's contribution rates has been mitigated due to the governor and legislature's decision to pay the $6 billion toward the unfunded liability. And I think it's an example of the importance, when possible, of pre-funding. And we're going to give you a legislative update here shortly, and we can talk about one of those pre-funding mechanisms that's being considered by the legislature. In addition to the payment toward the unfunded liability, the state plan was able to realize savings as a result of PEPRA. You saw that the PEPRA changes are beginning to be seen, and then higher than expected fiscal year returns for 2016-17 for a combined savings of about $277 million. And then the rising rates, as we talked with you about yesterday, are the result of the implementation of the lower discount rate, the changing demographic assumptions, and then rising employer payroll costs. Upon your approval today, the final valuation reports for employers will be completed by the end of July. On to the health program. As President Mather indicated, the healthcare beliefs, we've been able to finalize that work to the extent possible and get a final action on those today. We are also in the process of our rate development process, and we'll be able to provide more public information about that soon. So the healthcare team has really been focused on 3 areas, and that is promoting high-value care, improving the health outcomes and status of our members, their families, and the communities where they live, and reducing the overuse of ineffective or unnecessary medical care. We will present preliminary rates to the Pension and Health Benefits Committee next month during the May meeting, and we'll bring back final rates in June. So now on to some outreach activities. Last month, I was able to continue some of the regional office visits. This is something I really enjoy doing, and trying to find time in the schedule to do it is really important, and we're going to do a better job in finding more opportunities to do that. These regional offices, they operate as a satellite office of headquarters, and what I will tell you, they are highly engaged team members. They're very connected to the customers who are walking in, asking for advice and counsel, and they have the best ideas about how to make changes to work processes. So Corrine Carolyn, who is the manager at our contact center, she accompanied me on these visits, as well as Kara, and she documented a number of ideas that she's brought back to headquarters to work on implementation. So it's really clear to see how passionate our team members are about the primary duty that we all have in serving our members. In one other external outreach activity that I'd like to mention is last week I was able to participate in a local national public radio interview for a program called Insight. That recording is available on our website, as well as I did send that to you all directly. It's a show dedicated to in-depth interviews about current events, and the host was able to ask me a number of questions about our Solid Foundation for the Future report that I mentioned earlier. It was a great tool to guide the conversation and show the positive trajectory of the fund. And I was also able to directly address some of our critics' concerns that the fund is insolvent, as well as address our philosophy related to divestment, and that engagement with the scale and the size of CalPERS engagement really does matter. I was invited back in a few months to provide an update, and I look forward to continuing that dialogue with the show's host. So on to some internal activities, which again I think are really important to talk about, because it does make CalPERS the employer of choice, helps us with our recruitment as well as our retention. So next week on April 24th, the executive team and I will be able to recognize the Apex Award. It's at a breakfast to congratulate the recipients on their outstanding contributions. That will be followed the next day on April 25th with a graduation ceremony for our pilot Emerging Leader Program participants. And we're very excited about this program. It's designed to provide pre-leadership training and coaching to some of our most promising, motivated team members. It's an opportunity for them to determine whether leadership is really part of the career that they want to continue to move forward in. Gives them a little exposure before they have the responsibilities of actually being a leader. And I think what we have heard, and I'll hear more about this during the breakfast, is that this program was really well received by both the participants as well as the mentors. And this is one of several talent management initiatives that our human resources teams are working on to proactively plan for the leadership needs for tomorrow that we will have, when many of our current leaders are beginning to retire or schedule their retirement dates. Then on the 26th, April's going to be a busy month. The very next day, we'll host our first ever wellness fair, which is really interesting. This is the first time we will be providing this event to our team. It will feature health screenings, fitness challenge, and health exhibits to encourage team members to embrace wellness resources that we have to offer. And then as the week winds down, the March of Dimes Walk for Babies will take place on Saturday, April 28th. CalPERS employees will take part in this walk and have done so each year and are passionate for this cause. And then that will be followed May 8th through 10 with our annual Career and Education Fair here on CalPERS campus. And this is an annual 3-day event which provides fundamental resources to help our team members grow in their careers and to highlight the work we do with exhibits showcasing our divisions and human resource programs. And then new this year is a special mentoring hour on the first day that will help employees connect with team leaders and mentors across the organization. And then at last but not least is the Susan G. Komen Race for the Cure to raise money for breast cancer research and supportive services. I would say this is one of the most important events for the team here at CalPERS and gets high levels of participation. And then in closing, I will end with investment performance year to date. The total fiscal year to date performance is 8.3. The rolling 1-year return of the fund is 12.4. The 3-year return is 6.8. The 5-year return is 8.4. The 10-year return is 5.4. The 20-year return is 6.4. And that concludes my remarks, and I'm happy to take questions.
Thank you. Ms. Brown.
Thank you, Madam Chair. Actually, my question is for you, Madam Chair, on your opening comments regarding selecting legal counsel. You said there was a subcommittee. I was just wondering who specifically is on that subcommittee and how they were selected.
Sure. So I selected 4 members. I selected Mr. Gillihan, Dana Hollinger, and Mr. Fechner. And I based it really on their experience. Ms. Hollinger is a legal professional, and she has had long experience in that profession, so I thought she was an appropriate person to select. Mr. Gillihan also has had a lot of experience in selecting outside counsel, so I included him on the panel. And Mr. Fechner, as the prior board president and the sitting vice president, I thought was an appropriate selection as well.
Thank you. I'd just like to say for the record that I would like an opportunity to serve on future subcommittees that select our professional consultants.
I will absolutely consider that. Thank you, Ms. Brown. Okay, I see no further requests from the committee. So we'll move on to agenda item number 5, which is the action consent item. I would just note for the committee that there is a revised travel approval item in your folder.
Move approval.
Moved by Mr. Fechner.
Second.
Seconded by Ms. Hollinger. Any discussion on the motion? Seeing none, all those in favor say aye.
Aye.
All opposed? Motion passes. I've had no request to pull anything off of consent, so we'll move on to the committee reports and actions. For Investment Committee, I will call on Mr. Costigan, Vice Chair of that committee.
Thank you, Madam President. The Investment Committee met on April 16th, 2018, and I apologize, I'm fighting a bad cold, so. The committee approved the following. Agenda item 5A, to approve the staff recommended asset allocation glide path for CalPERS supplemental income plan in the affiliate trust asset allocation review supplemental income plans. The committee, the committee received reports on the following topics: dual class non-voting shares update and debate, the proposed revisions to governance and sustainability principles, and corporate governance update, proxy voting, shareholder campaigns, and corporate engagement. The chair, Mr. Jones, directed staff to do the following: to facilitate consultation between CalPERS staff, the State Treasurer's Office, and RBK, Inc. regarding the CalPERS 2013 Supplemental Income Program review, to provide the committee with a breakdown of industry sectors of dual class and no vote companies, ensuring an analysis of possible exclusion of no vote shares as part of the next midpoint ALM benchmark review, to allow for further discussion in May during the total fund policy first reading for further discussion regarding corporate board diversity, to bring back in May's total fund policy the first reading potential updated governance and sustainability principles language around sexual harassment, clawbacks, and arbitration, to reach out to the investment staff of the pension funds of Florida and Minnesota to understand their executive compensation voting framework. The committee heard public comment on support of staff work on corporate governance update proxy voting on CEO pay and on the return of the ESG investments. And at this time, I'd like to share some highlights of what to expect at the April Investment Committee meeting. We will have a review of the affiliate trust asset allocation for LRS, JRS, JRS2, and the SERP, an update of the corporate governance regarding proxy voting, shareholder campaigns, and corporate engagement, and we will also have the first reading of the revision to the total fund and private equity programs policies. The next meeting of the Investment Committee is scheduled for May 14th, 2018 in Sacramento, California, and that's my report, Madam President.
Thank you. Thank you very much, Mr. Costigan. Before I move on to the next item, I've had a request to speak on item 5B, so I will take that up now. Mr. Snow, would you please come forward? You can take one of these seats to my left. The microphone is turned on. If you could identify yourself and your affiliation for the record, and you'll have 3 minutes with which to speak.
Good morning.
Morning.
It's on, right? Okay. Brian Snow. I'm a CalPERS member. I'm also a member of Corona Police Officers Association. It's nice to be back, a little break. But I appreciate the opportunity to speak. I'm talking about 5B, the travel requests. And it was interesting, I know last month there was some travel requests approved as well. And one of the issues that we're having is when, I know that CalPERS and Marcy had mentioned it, or Ms. Frost had mentioned about the improvements and the returns and the cost savings, which are all great, but we know that it goes up and down. So it's the long term, I don't know what that's going to look like, and the returns don't look that great for that long term, the 10 and 20 year. One of the issues that we're having or the questions that we're having is how are we sending people out of the country? I know some of these conferences are good, they're nice, but that's money we're spending that we could be saving. Ms. Frost also mentioned about visiting members and serving the members, and I think the board should take that example. Instead of going to all these places all over the world, you should be visiting membership in California and working to improve that long-term sustainability that we talk about. So I would seriously consider, as a member, I'm asking you to seriously consider those those long-term trips that are costing CalPERS members money, and the investments that are made, the returns, that should be spent on members and what we're doing here in California. Thank you.
Thank you very much. I've also had a request from Ms. Brown to pull out 6C, but that is not an action item. On finance and admin. Okay, thank you. Okay, then we'll move on now to the Pension and Health Benefits Committee, and for that I'll call on the chair, Mr. Fechner.
Thank you, Madam President. Pension and Health Committee met on April 17, 2018. The committee recommends, and I move, the board approve the following. Agenda item 5, adopt the revised health beliefs as shown in attachment 1 of the agenda item, option 1, which contains suggested committee member changes provided at the March 2018 PHBC meeting.
On motion by committee, all those in favor say aye.
Aye.
All opposed? Motion passes.
The committee received reports on the following topics. A potential reference pricing pilot for medication covered under the pharmacy benefits for basic health plans serviced by Optum Rx for plan year 2019 and beyond. An update on the self-funded preferred provider organization health plan benefit design changes implemented January 8, 2018 and proposed changes for 2019. The committee received public comment from Larry Woodson, California State Retirees, regarding potential increase in cost to preferred provider organization members, particularly in the PERS care plan. The chair directed staff to bring back an analysis back to the committee regarding statistics on therapeutic class outcomes. Also to share with the board how CalPERS is addressing the ambulatory surgery center concerns highlighted during public comment. This time I'd like to share some highlights of what to expect at the May PHBC meeting. The committee will review the Gen 4 solicitation award, proposed benefit design change for 2019, and receive information on the preliminary 2019 health rates and contracts. The next meeting of the PHBC is scheduled for May 15th, 2018 in Sacramento, California. That concludes my report, Madam President.
Thank you very much, Mr. Fechner. The next item on the agenda is the Finance and Administration Committee report. For that, I'll call on the chair if you could, Ms. Taylor.
Thank you. The Finance and Administration Committee met on April 17th, 2018. The committee recommends, and I move the board approve the following. Agenda item 3B, approve the April 2018 prospective report of solicitations, contracts, purchase orders, and letters of engagement.
On motion by the committee, any discussion by the committee? Seeing none, all those in favor say aye.
Aye.
All opposed? Motion passes.
Agenda item 3C, approve the 1959 Survivor Benefit Program Actuarial Valuation Report as of June 30th, 2017, and adopt the employer and employee monthly premiums for fiscal year 2018-19.
On motion by committee, any discussion by the board? Seeing none, all those in favor say aye. Aye. All opposed? Motion passes.
Agenda item 5A, approve the fiscal year 2018-19 annual budget proposal first reading in the amount of $1.68,636,000 and 2,875 positions, and approve the transmittal of this agenda item.
On motion by committee, any discussion on the motion? Seeing none, all those in favor say aye.
Aye.
All opposed? Motion passes.
Agenda item 6A, approve the proposed elected board member percentages of time to be spent on the board related to duties on board and committee selections, with a modification to David Miller to state an increase of up to 82%.
On motion by committee, any discussion on the motion? Seeing none, all those in favor say aye.
Aye.
All opposed? Please note, was that you, Mr. Costigan? Please note Mr. Costigan's no.
Okay. Approve the extension of, item 6B, approve the extension of current backup, restoration, and disaster recovery services contract through September 30th, 2018, if necessary, at a total cost of approximately $450,000.
On motion by committee, any discussion on the motion? Seeing none, all those in favor say aye. Aye. All opposed? Motion passes.
I'm pulling 6C. We're moving.
You can just
Go ahead and go?
Yeah, go ahead.
Okay.
Please. Yeah.
Agenda item 6C, approve the proposed amendment, section 554.7 of the California Code of Regulations, and approve the submittal of the final rulemaking package of the office to the Office of Administrative Law.
On motion by committee, discussion on the motion, Ms. Brown.
Thank you. I want to start off by thanking the staff for fixing the signature on the ballot and removing the markings that could identify voters, but there are still plenty of problems with our current voting process, and I sincerely hope we will take those up and fix them. Specifically, the phone voting is very problematic. It does not work correctly. Online voting is unconstitutional, and we'll have a much longer discussion about that. Also, the paper ballots, for those of you who don't know, are mailed to a printing place in Washington, where they scan them daily, and they send them over the internet to another voting place in La Jolla, California, where they are ultimately tabulated without anybody watching. And I'm telling you, it's a bad process that's open for shenanigans or worse. And I hope we actually end up fixing that process. So I will be voting no on item 6C.
Okay, any further discussion on the motion? Seeing none, all those in favor say aye.
Aye.
All opposed? Motion, please note Ms. Brown's no. Motion passes. Agenda item 7A, please continue.
Agenda item 7A, adopt the state employer and member contribution rates for the period of July 1st, 2018 to June 30th, 2019.
On motion by committee, any discussion on the motion? Seeing none, all those in favor say aye. Aye. All opposed? Motion passes.
Agenda item 7B, adopt an employer contribution rate of 18.062% for the schools pool and a member contribution rate of 7% for schools employees, subject to the Public Employees Pension Reform Act of 2013 for the period of July 1st, 2018 to June 30th, 2019.
On motion by committee, any discussion on the motion? Seeing none, all those in favor say aye.
Aye.
All opposed? Motion passes.
The committee received reports on the following topics: semi-annual health plan financial report, reporting on participating employers, long-term care evaluation report. The chair directed staff to review the board member employer reimbursement process and come back with reporting definitions, including reportable hours, how hours are validated, and possible revised caps and thresholds, and propose seeking legislation to increase the monthly stipends for retiree and appointed board members. The committee heard public comment on the following topics: the annual review of board member employer reimbursements, the proposed Board of Administration election regulation and public hearing, schools valuation and employer-employee contribution rates, semi-annual health plan financial report, and reporting on participating employers. At this time, I'd like to share with you some highlights of what to expect at the May Finance and Administration Committee meeting: the 2018-19 annual budget proposal second reading, asset and liability transfer to the San Bernardino County Employees Retirement Association, extension of third-party administrator contract for the supplemental income plan. The next finance meeting of the Finance and Administration Committee meeting is scheduled for May 15th, 2018 in Sacramento, California. And that is my report.
Thank you very much, Ms. Taylor. So that brings us to, we had no committee meetings for performance comp and talent management, risk and audit, or board governance. So that brings us to agenda item number 8, approval of committee delegations. Mr. Jacobs.
Good morning, President Mather and committee members, or board members, that is. I always get the most controversial and complex items, so that's why I'm here before you on this item. This one brings together all the revisions to the committee delegations for final board approval. These were committee delegations that were reviewed and approved in committee in the last couple of months. The only substantive change is to the delegation for the Performance, Compensation, and Talent Management Committee, and those revisions are outlined on the first page of the agenda item. So with that, I will conclude my presentation.
Thank you. This is an action item. What's the pleasure of the committee? Moved by Mr. Costigan, seconded by Ms. Taylor. On any discussion on the motion? Seeing none, all those in favor say aye. Aye. All opposed? Motion passes. So that brings us now to agenda item number 9, which is proposed decisions of administrative law judges. And for that, I'll call on Mr. Fechner.
Thank you, Madam President. I move the board adopts the proposed decisions at agenda item 9A through 9G as the board's own decisions, with minor modifications to agenda items 9A, 9D, and 9F as argued by staff.
Second.
Motion was seconded by Mr. Miller, made by Mr. Fechner. Any discussion on the motion? Any request to pull any item separately, consider any item separately? Seeing none, all those in favor say aye.
Aye.
All opposed? Motion passes. Agenda item number 10, petitions for reconsideration. Again, Mr. Fechner.
I move the board deny the petitions of reconsideration at agenda items 10A through 10C.
Motion's been made and seconded by Mr. Miller. Made by Mr. Fechner, seconded by Mr. Miller. Any discussion on the motion? Seeing none, all those in favor say aye. Aye. All opposed? Motion passes. That brings me now to agenda item number 11, which is the full board hearing. Let's open the record at this time for the full board hearing in the appeal of CHP officer Denise C. Patton, CalPERS case number 2016-1260. Let us first take roll call, please.
Kara, sorry. Sorry about that. Priya Mathur.
I'm here.
Rob Fechner.
Good morning.
Margaret Brown. Here. Steve Rose for John Chung.
Here.
Richard Costigan.
Here.
Richard Gillihan.
Here.
Dana Hollinger.
Here.
Henry Jones.
Excused.
David Miller.
Here.
Ramon Rubicava.
Here.
Bill Slayton. Teresa Taylor. And Lynn Paquin for Betty Yee.
Thank you. The proposed decision was originally considered by the board on February 14th, 2018, when the board declined to adopt the proposed decision and in its stead scheduled the matter for a full board hearing. I note for the record that all parties have received notice of this full board hearing, along with copies of the Statement of Policy and Procedures for full board hearings before the board. In addition, all parties have been informed in writing that oral argument will be limited to 10 minutes each for each position, and rebuttal will be limited to 3 minutes for each position. Would counsel for each party please take a moment to introduce themselves, starting with staff's counsel and then Officer Patton's counsel? Oh, if you could turn on your microphone, please. It's been turned on for you. Oh, no, not yet. There it is. Now you're on.
Okay. Thank you. Good morning, Madam President, members of the board. My name is Cynthia Rodriguez, and I'm an attorney here at CalPERS.
Good morning, Madam President, members of the board. I'm Jill Suzanne Breslaw. I'm attorney for Ms. Patton, who is sitting next to me.
Good morning, members of the board and Madam President. I'm Marguerite Seaborn, and I'm on the CalPERS legal team.
Thank you. Okay. Well, thank you. Let the record also reflect that Chirag Shah, the board's independent counsel on full board hearings and proposed decisions from the Office of Administrative Hearings, is here now and will be advising members of the board on procedural as well as substantive issues that arise in this proceeding should board members have questions. Mr. Shah will also provide a brief summary of the case before we begin oral arguments. As stated previously, each position will have 10 minutes for oral argument. Ms. Rodriguez will first have 10 minutes to present staff's argument. After that, Ms. Breslaw will have 10 minutes to present Officer Patton's argument. Neither side is compelled to use the full 10 minutes. However, if a party concludes argument in less than the time allotted, it will not be permitted to carry over any remaining time to any other portion of this proceeding. After both sides have presented oral argument, each side will be given 3 minutes for rebuttal argument in the same order as the original presentation. First, Ms. Rodriguez, then Ms. Breslaw. Here, too, the parties may, but do not have to, use the entire time allocated for rebuttal. But if a party decides to use less time, there will not be another opportunity to use any remaining time. There is a timer in this room which will be set for 10 minutes for initial argument and 3 minutes for rebuttals. The timer will begin when you start to speak. Please pay close attention to the timer, which is in front of me here, as you make your presentations in order to avoid going over your allotted time. When the timer's light turns red, your time will have expired, and I will so indicate. After all sides' arguments and rebuttals are concluded, the board may ask questions of any of the parties to this proceeding, as well as our independent counsel. The alternatives available to the board are set forth at agenda item 11. Any questions so far? Do all parties understand the procedure?
We do, Your Honor.
Thank you. Now then, Mr. Shah, please provide a summary of this case.
Good morning, President Mather, members of the board. As you said, my name is Chirag Shah, and I'm the board's independent counsel on full board hearings. Now comes the proposed decision in the case of CHP officer Denise C. Patton. Officer Patton, who served the state of California for 18 years, seeks an industrial disability retirement on the basis of an orthopedic condition, primarily involving her neck and back. Officer Patton has served 14 of the 18 years as a motorcycle police officer, during which time she asserts that she suffered a number of injuries as outlined in the proposed decisions, factual findings 4 through 13. Like all cases such as the one before the board today, Officer Patton bears the burden of persuasion. As such, Officer Patton must produce sufficient medical evidence in the form of competent medical opinion to persuade the board by a preponderance of the evidence, more likely than not, that she was disabled as defined in the Public Employees Retirement Law, Section 20026. In the proposed decision, the administrative law judge finds that Officer Patton failed to satisfy her burden to produce persuasive medical evidence establishing that she was substantially incapacitated as defined in Section 20026 at the time of her application. Officer Patton obviously disagrees with this conclusion and urges the board to issue its own decision, finding that she is disabled for purposes of the parole. Staff, on the other hand, agrees with the proposed decision and urges the board to adopt it as its own decision in its entirety. The details of the parties' arguments, as well as the entire administrative record, are before the board at agenda item 11. With that, Madam President, I conclude my brief summary of the case.
Thank you very much, Mr. Shah. Let us now turn to preliminary evidentiary issues. As all parties are aware, we are not here to relitigate factual issues or resubmit evidence into the administrative record. However, in rare circumstances, the interest of achieving a just result may require consideration of newly discovered, relevant documentary evidence which could not, with reasonable diligence, have been discovered and produced at the hearing before the administrative law judge, and which therefore is not part of the administrative record. The board's procedures make it clear that under no circumstance may the board accept new testimonial evidence, witness testimony, or any kind of examination or cross-examination of anyone, including board members, in today's proceeding. Under the board's procedure, requests to introduce newly discovered documentary evidence must be submitted in writing to the board secretary no later than the due date for written argument, which in this case was April 4th of 2018. In order to avoid interruptions during each party's respective time today, please let us know if either party has any relevant, newly discovered evidence which could not have been discovered and produced at the hearing that it seeks to be admitted into the administrative record today, as to which a timely written request was submitted to the board.
No.
No.
No, we do not.
Thank you. Seeing that there are no requests to submit newly discovered evidence, let us begin oral arguments. Ms. Rodriguez, please present staff's argument. Please start the clock for 10 minutes.
Thank you. The case we have here today is from an area of law which is well-established: industrial disability retirement. The issue presented in this case is a regular issue in the cases that we have here at CalPERS. Members or their employers request disability retirement, and CalPERS staff reviews these requests and determines if the cases rise to the level of the long-held standard for CalPERS disability retirement. That standard is that the claimed medical condition has resulted in a substantial incapacity of the employee to perform the duties of their job. Whenever this issue arises, CalPERS must look to protecting the rights of civil servants whose employers are trying to remove them from their jobs, and also protect the system when a claimed disability does not rise to the level of a substantial incapacity to perform that job. This is a very significant and reoccurring civil service issue, which has resulted in a long and clear-held standard of proof. The law and reasonable standards hold that the employee must have a current inability, not the risk of a future injury or incapacity, to perform their job, and cannot be eligible for disability retirement because of that risk of a future injury, as was the issue here in the case with Officer Patton. Both CalPERS and Officer Patton provided doctors for medical testimony, and the administrative law judge made very specific findings based on the clear evidence presented, finding that this was not a disability retirement situation or an industrial disability retirement situation, but instead is that situation where future injury is the basis of the claim. The experienced administrative law judge used sound reasoning in his 17-page determination to consider each of the California Highway Patrol job duties individually, and to find that Officer Patton is capable of performing her job duties and should not be disability retired due to fears of future injury risks. This case allows us to uphold the long-held and fair standards of determining the entitlement of civil service employees to maintain their employment and the obligation of CalPERS to determine when the disability standards are met. Officer Patton was a CHP officer in the Standard Patrol and Motorcycle Officer Program, a well-regarded profession requiring dangerous and difficult work. She has had automobile and motorcycle accidents as an employee working in a vehicle for a regular shift work on a daily basis is inclined to have. Ultimately, she's always been released to regular duty after those accidents, most of which required no time off. Officer Patton was working full-time without restrictions when she was last at work, when she opened her car door against gravity and weather, and the strain from that was the last issue at her work. She saw her doctors, she saw an independent medical examiner, and she remained off work. She filed a workers' compensation claim and an application for industrial disability retirement. The most important issue at a hearing of this type is the existence or not of competent medical evidence of the member's claimed disability, her substantial incapacity to perform the job duties. There's also the issue of what are the job duties of the member's position as a CHP officer. Luckily for the evaluation in this case, the job duties of a CHP officer are the most specifically enumerated duties of any state employment. The 14 critical tasks of a CHP officer have been delineated for many years and are referenced in both the California Government Code and the California Vehicle Code. The administrative law judge in this case carefully reviewed and reported on his decision of each of these 14 tasks and Officer Patton's ability to perform them. CalPERS called as a witness the independent medical examiner who determined from his examination that Officer Patton was medically capable of performing each job duty. The independent medical examiner testified truthfully that there was no medical reason Officer Patton could not perform these duties and repetitions of the duties, even when questions about repeated performances beyond the job requirements. Dr. Hinrichsen, the only board-certified orthopedic surgeon to testify, determined from his findings on physical exam that Officer Patton, on his physical exam of Officer Patton and his review of her test results, as well as other medical reports, that Officer Patton did not show an orthopedic issue causing substantial incapacity to perform her job duty. The testimony of the two doctors for Officer Patton was determined by the administrative law judge to be unpersuasive. This experienced administrative law judge, who regularly watches and determines the weight and credibility of medical witnesses, found the officer's expert medical evidence insufficient for specific important reasons. Neither of Officer Patton's doctors was a specialist or board certified in orthopedic conditions, the issue at hand, although Officer Patton had seen orthopedists. First of all, Dr. Richmond, a neurologist, testified that Officer Patton did not have a neurologic condition that incapacitated her from her work. He then went on to comment on other medical reports from medical fields that were not in his expertise, why he thought those reports satisfied the disability standard. This was not persuasive testimony for the administrative law judge, as Dr. Richmond was not the preparer of those reports, and they were in a field quite different from his own. Dr. Shen, a physical medicine rehabilitation expert, the area of his board certification, was not an orthopedic specialist, but a rehabilitation specialist. His testimony on direct examination was notable for what it left out. He testified that Officer Patton was disabled, but was not asked why he made that determination. He found her problem to be chronic pain and said that she should not or could not perform many of the tasks of a CHP officer. The law is clear that discomfort or danger are insufficient to find substantial incapacity. The important issue of what Dr. Shen based his determination of incapacity on did not come up until cross-examination. At that point, he clarified that the reason she could not perform her duties was not incapacity so much as an aversion to risk. He testified that she had lost capacity that she had not lost capacity so much as she had, quote, lost motor control wisdom, end quote, and was at risk for future injury due to her fears and uncertainty. He admitted that her EMG was fine, but that her medical safety was at risk because she was at risk for future injuries. He said, quote, I'm just saying that she's at a significant risk for those events to happen if she were to take on those challenges, end quote. This was not a determination that she was medically incapacitated, but that she was limited by her evolving perception of the risks she was putting herself in. The important consideration here is that this is a job that has always been full of risk from the moment of being hired. That is the reason that safety, or police, CHP, firefighter, among other work designations, is paid commensurate with those risks, offered higher pension values, and deserves the admiration of the public and voters. The fact that these employees take these risks is part of the calculation of their remuneration. when an employee is no longer willing to take the risk, that is not a medical condition. That is a reasonable decision based on a new perception of limitations. In this case, if the officer is no longer willing to take the risks inherent in her job or has a higher level of fear of the incapacities that are caused by injury, or is unable to quell the fear of future injury due to a changed perceptions of the risks that exist in a safety job, the answer is to seek other less risky employment, state or otherwise, not to be retired for disability prior to retirement age. Civil servants are entitled to be protected from aspersions to their abilities because of their genders, experiences, or non-disabling injuries. Those issues which are not related to medical capacity are not part of the disability retirement decision-making process. Civil servants have a right to their jobs and a duty to perform them unless there is competent medical evidence to the contrary. In this case, the medical evidence presented at the hearing makes it clear that Officer Patton can do this job. We ask that the board adopt the administrative law judge's determination. Thank you.
Thank you very much. Ms. Rodriguez, please start the clock for 10 minutes for Ms. Breslau to present Officer Patton's position.
Thank you, Madam President, members of the board. In 1996, Denise Patton took an oath to honestly and conscientiously serve the people and uphold and maintain the honor and integrity of the CHP. She also vowed to lay down my life rather than swerve from the path of duty. She has almost laid it down several times, for which she was off many times. The 00 accident, where she was knocked off the motorcycle and cartwheeled all over Wilshire Boulevard in L.A. The 2001 accident where a lady ran a red light or ran a stop sign right in front of her. She T-boned her at the wheel well, the strongest part of the car, left pieces of her motorcycle in the car, went up over the windshield, boot scuff marks on the roof, and landed on her head and ended up in the Cedars-Sinai Hospital Trauma Intensive Care Unit for almost 4 days. You don't go in there unless they're worried about what they've got with you. There's no dispute that she's been in all these accidents. There was no dispute that after returning to work from the accident put her into Cedars, she got hit again on the way to a doctor. She was off again. Then she went back a couple of months later, worked a little light duty, and got back on the motorcycle, the dangerous job of a motorcycle. She's not afraid of anything, this woman. In 2003, she's a pedestrian officer on the side of the road, and somebody else sees something, thinks somebody's coming in his lane, hit him. What the judge didn't tell you on all of these, one was, first off, that she was in Cedars-Sinai. Second off, that she was hit again, which put her overnight into the trauma unit at Harbor UCLA. The man hit her on her hip. She went onto the windshield of a 70-mile-an-hour car, put her head through it with the helmet, and then got thrown 25 feet down an embankment. She was off several months after that. Then she winds up having a disc replacement in her neck, so now she has a partially prosthetic spine. She goes to Sacramento. She's in a car because it's rainy and you can't ride motorcycles on the side of the road, and she is hit again. She is off again. This thing on the 14th, on the 30th of November 2014 was the straw that broke the camel's back. She was on the northbound 99 to the 50, and it was at an angle. It was literally a 45-degree angle. She was trying to pull that door. This was not trivial, as Dr. Henriksen said. Now, the issue here is the 14 critical tasks. Sergeant Ted White testified, you have to be able to do these on any given day at any given time. You can't decline to do it because you've already done it several times. So he also said you separate uncooperative persons of 160 to 200 pounds, for example. How many? Is it a road rage incident? Do I and 2 or 3 of you get into a wreck because I'm a bad driver and we're acting nice and calm and peaceful, but the people that we've hit are not, and she has to come up and separate them? How many people? Is it 2? Is it 3? Is it 4? Is it road rage? Is it a domestic situation going on that she winds up being sent to, which is unusual for highway patrol, but happens? Dr. Feder could not be here. He is 78 years old. He fell. He's failing. I would have loved to bring him. He doesn't even do depots in his office anymore. He does them from his house. We brought Dr. Richmond because orthopedists send individuals to neurologists to find out if they have some radiculopathy. Dr. Henriksen testified that he thought the temperature was off. in the room. Dr. Richmond is not only board certified in neurology, he's board certified in electromyography and the spine disorders. He's the only one board certified in that. She saw Dr. Shin because workers' compensation doctors she's been seeing before do not want to deal with the workers' compensation situations that the state has provided. They went to medical school to heal people, not to write a report in whatever format the current iteration of the legislature wants it written. There are so many doctors that are leaving workers' comp. Pretty soon we're going to have none. But Dr. Feder was quite clear that she lacks the ability. She has a physical inability to perform the critical tasks, and he's been an AME, an agreed medical examiner, for years. So is Dr. Richmond, both of whom wrote well over 100 pages of reports and record reviews, if you read them. Denise Patton, clearly, as I put in my brief, from the doctor's things, could not lift, carry an individual resisting arrest 20 to 35 feet, 160 to 200 pounds. She can't, maybe she can, she's hypermobile, so maybe, or hyperflexible, maybe she can twist herself into a pretzel and get into a car. And maybe she can pull out, somebody's two smaller kids. But according to this, then I guess she's done it already 4 times, and now she does it 2 more. Is she allowed to skip the 2 people in the front seat? The answer is no. And if one of them is jammed in, his leg or something is literally fused with this mangled upside down car, she does not have the strength in her neck, in her low back, especially her low back, to pull these people out. She cannot do these. And Dr. Richmond testified to it, and Dr. Shin testified to it. It's in my brief exactly where. Dr. Henriksen Dr. Richmond, when he testified, and Dr. Shin, they both said which one of these she can do. Mind you, she's got 25 pounds around her waist at all times while she's doing this. Dr. Henriksen says the 25-pound gun belt some people find supportive. How can you buy anything he says with that? That's absurd. Ted White testified otherwise. I had several other officers. I had $3,000 of subpoenaed highway patrol officers, sergeants, lieutenants, and a captain, and a chief willing to testify. I could probably get the commissioner if I try. I was precluded from putting that evidence on because it's not important. Well, if the CHP is not, if their impressions of her abilities way back when she could get into the fistfights and the altercations and back up her partners, and they've seen the diminution in her abilities to date, if that's not important, I don't know what is. But both Dr. Richmond and Dr. Shin testified honestly as to the things that she can do and the things that she can't. There used to be a different critical task statement for the 14 criticals that went in when they got rid of the 19. And I actually have a copy of it. And here's a lower and upper extremity dynamic muscle strength and aerobic power. You were supposed to do a 100-yard chase, physically subdue and handcuff a combative suspect. Well, that's why you would chase them now 100 yards or so, hopefully catch them. You're supposed to remove spill loads of traffic hazards, lumber, large rocks, etc. That's in there now, but dressers, mattresses, whatever you have to remove, lamb, animals. You're supposed to be able to extract a 200-pound victim, lift, carry, or drag the victim 50 feet. That's the old one. Now it's 5 to 35. Well, if you extract that victim somewhere out of the number 1 lane, and you got to go 5 lanes over, 12-foot lanes, that's more than 60 feet. Get him onto the shoulder, get him where he's out of, you might be doing 75 feet. But all of these things, they separate uncooperative persons, pull, drag heavy objects. I tried to give an example of a stolen car that she doesn't know is stolen, and the driver doesn't know that she doesn't know it's stolen, and he goes to the back of the car, and she's telling him, as they're supposed to, sir, please step back in the car. Please get back in the car. Okay, sir, please step to the shoulder. But she never gets that far because this ex-felon from, some White Aryan Brotherhood thing up in Pelican, whatever it is, has drugs in the car that he wants to go sell because he's ordered to do it, and he's all over her and the fight's on. She's fighting for her life. These situations happen. And here come Tom and Dick or Harry, and they're coming home from their carpool, and these citizens come to help her out. Well, what happens if the guy gets her gun? Okay, now you have 3 shot citizens as well. Let me tell you, that is very expensive for the state of California. But these are reasonably foreseeable problems when you put an officer that even the CHP knows, and they're the ones who gave her the options letter and said you need to go. These are reasonably foreseeable issues that can arise and can cost the people of the state of California an awful lot of money. I am aware of the Mansford case. I am aware of the Hosford case. I am aware of the Starnes, the late Willie Starnes case. They all sit there just like the CalPERS medical qualifications. It's the inability to perform the essential functions, lifting, carrying, pulling, pushing. That's what Dr. Fetter wrote. It's what Dr. Richmond says. It's what Dr. Shin says. It's the inability to perform the essential functions of the actual and present job duties that determines whether the member is substantially incapacitated. If you looked at synonyms for ability, you get capacity. Inability, incapacity. Inability, has physical inability, as Dr. Fetter has written, to perform the tasks alone. Substantial means some inability. It doesn't mean all inability. Well, Dr. Fetter, Dr. Richmond, his testimony, which the judge didn't want to listen to because he's a neurologist, when orthopedics sends you to neurologists so you can have these tests done. And by the way, Dr. Henriksen never looked at some of the records that were sent until the day before, and I served them and have FedEx proof of delivery on them all the way starting in June right up through October. So these things were sent. Dr. Fields and Dr. Henry's reports and whatever else state comp they had were sent. In one hand, workers' comp starts to take away medical care by saying we have to send you.
Your time has expired. Thank you, Ms. Breslau. Ms. Rodriguez, would you like to offer a rebuttal at this time?
Thank you very much.
Please start the clock for 3 minutes for staff's rebuttal. Now you may proceed.
Thank you. CalPERS operates under the law. The Pearl has specific requirements for how we follow the rules of the Administrative Procedures Act, and all these hearings are conducted appropriately and legally. Hearsay testimony is not sufficient under the Administrative Procedures Act to make a determination. Dr. Fetter did not appear. Having someone else talk about his reports is insufficient to give those statements the weight sufficient to carry this determination. Scenarios can always be thought up that will frighten or make us insecure about legal decisions we have to make. There's always worst case scenarios where no one can fix a situation of danger for the citizens of the state. That is not the reliable and fair way to conduct a hearing and to make a determination for whether or not someone has met the standards required. Incidences that happened in 2000, 2001, 2003, that an employee continued to work for 10 to 15 years afterwards without a break, do not offer sufficient evidence to make those determinations, particularly when there are no reports of those incidents, no medical substantiation of them, and no reason to assume that those will create an incapacity without competent medical evidence. Officers who work alongside somebody are not competent to offer medical evidence of their capacity. That is done through the doctors who appear and the doctors who offer testimony and direct evidence. In this case, we were fortunate to have 3 physicians testify, 2 of whom were doctors of Officer Patton, and a very experienced administrative law judge was able to determine that they did not present sufficient evidence to establish a medical incapacity, substantial incapacity to perform her job duties. The standards which CalPERS has followed for many, many years have created a reliable platform for members to understand how to present their issues and to be determined to be capacitated or not. And it creates a fair and reasonable way to determine a very important issue, which is whether or not someone is legally entitled to the relief they are seeking. Without that, CalPERS would be making an individualistic decision based on non-admissible evidence in every case. We ask again that the board follow the proposed decision of the administrative law judge. Thank you.
Thank you, Ms. Rodriguez. Ms. Breslau, would you like to offer a rebuttal?
Sure, Your Honor. Thank you very much.
Then please, sorry, before you start, please start the clock for another 3 minutes for Officer Patton's rebuttal. Please proceed.
Thank you. First of all, there was no dispute as to all the injuries. There was no dispute as to the accidents. Again, no dispute as to the injuries. If there was, Dr. Henriksen would have disputed every single injury. He just disputed the extent of the low back injury. Now, counsel thinks these scenarios, or this one scenario is funny, and I would, or is not accurate. We can look at the worst case. These have been happening all over the country. And a worst case scenario in California, I would ask you, had you ever heard the name Officer Don Burt? Because that scenario happened to him, and it is a training scenario in every police academy in this country. So, we're not trying to scare anybody, but you have a duty, and the Highway Patrol has a duty. They have a duty to pull alcoholic officers off the road, drug-using officers off the road, psychiatrically disabled officers off the road. Those superiors are supposed to know that, and officers are supposed to know that. They also have a duty not to put an officer who can't pull all of us out of a vehicle. Maybe she can get me. Maybe she can get you, Madam President. Maybe she's not going to be able to pull out somebody else here. Or maybe she can get a couple of little kids out of a burning car. Maybe she can do some of these. Please look at the doctor's testimony for what they can do and what they can't. For Dr. Henriksen to say, hey, she can do this 5 times a day if need be. 5 times a day? No. The only credible testimony came from Dr. Richmond and Dr. Shin. And when you read the reports, you should be able to see that. But, CalPERS, I just have to go back to this, and I have to go back to 2268 of the Vehicle Code section. She can't continue to work. She can't work light duty permanently. CHP has no such jobs for her permanently. Therefore, she is entitled to a disability retirement, and she has earned that, leaving pieces of her body in 3 different divisions of the state of California Department of the Highway Patrol. This woman she's actually, there's only a handful. There have only been a handful of female motorcycle officers. Ramona Prieto, who retired out of Commissioner's Office. Captain Gretchen Jacobs, who retired out of the Antelope Valley Office. Sergeant Karen Tohidi, retired out of West Valley. And Anne Marie, whose name I can't recall, retired out of West Valley. Right now, the ranking female motorcycle officer in the state of California is Denise Patton. Don't you think she would rather keep that? She would love to go back and sit on that motorcycle and ride around and serve the people of California. But one of the things that is said in all of these cases, including Hosford, is you must know what your own limitations are. She would be doing none of us a favor, and you would be doing none of us a favor, putting her on the road in a hazardous situation which is reasonably foreseeable that a citizen could be hurt.
Thank you. Thank you. At this time, I will entertain questions from the board. Are there any questions from the board? Mr. Costigan.
I might as well ask a few. So, I'm sorry, I have a little issue with your presentation. What really should have been is expert versus expert. And what I didn't necessarily hear was you moved to disqualify CalPERS medical experts. So first of all, Officer Patton, appreciate all you do. Okay, you may or may not know, I sit on the state personnel board, so I'm very familiar with our job descriptions, and I appreciate all you do. In fact, I have a high love for the patrol. I know both the current commissioner and the past commissioner very well, so what you do and any officer on Interstate 80 at 2 o'clock in the morning, I appreciate all you do. So please don't take questions as to the integrity of you as an officer or what you do, because we can't do what you do, and I just want to say I appreciate that. But what I didn't hear again was, this is just of 2 different medical experts. You have yours and you have CalPERS disagreeing as to whether or not she can go back to work. What I don't see in any of this is, where is CHP? I know you said you could get the commissioner to testify, but I see no CHP brief. I see no CHP letter. I don't see where she attempted to go back to work. Or am I not seeing that in the record?
No, CHP doesn't generally appear at these things. I'm not even sure if they're here. I thought they might be here today just to observe, but they generally do not appear. They are the ones who sent the options letter, and they actually tried to retire her after 2010, but didn't.
And I appreciate that. This is what concerned me, and I'm familiar with CHP, is when you said you could have had the commissioner here.
No,
you could have had
not
these
here.
folks here. Well, I'm sorry, that's what you said.
Oh, no, I meant if I have to, I had 2 sergeants, a captain, and several officers subpoenaed and at the Office of Administrative Hearing. Only the captain hadn't actually shown up. I had one there who sat there all day, and he was thrown off the stand because the ALJ decided he didn't need to hear any more about the 14 critical tasks, even though Ted White's testimony was uncontroverted. It's in his decision.
And that goes back to the point I was making.
Excuse me, Mr. Costigan, if we could just let her finish her answer. Thank you.
I wanted to put them all on. The ALJ, who's been doing this for 5 years, did not want to hear any more of them. He said, pick 2. I picked Sergeant Ted White, the motor training instructor at the academy who testified about the 14 criticals. He didn't want to hear that anymore, and he said while that testimony was uncontroverted, this is in his decision, while that testimony was uncontroverted, he was going to go with the 14 criticals, a piece of paper.
Okay.
What I'm saying is, you know, if I have to go take depositions, and council didn't want depositions, and council opposed my trying to put Feder on. She said we would oppose anything about having, and I tried to make a motion to put him on via video or something from home, and it was denied. It would have been not even at the board down there. It would have had to be from his house. I couldn't bring the other, by the way, doctors, orthopedic surgeons that she had. They're not practicing anymore. They're retired. They're gone. They're out.
Okay.
But yeah, if I had to do depositions or put a subpoena on them, I could put I've been doing this for 30 years with over 30 years with CHP. I know all those people also. If you're asking me why Disability and Retirement didn't file a brief, I mean, you know, you really have to ask them.
Okay. Mr. Costigan, did you have further questions? Okay, thank you. Mr. Miller.
Yes, we got a couple of questions, and first of all, my understanding was with these 14 requirements that a highway patrol officer has to be able to do all 14. That if I came out of academy and couldn't do any one of them, I couldn't be hired. Not whether I could do any one of them, you know, every few months, or just one of them today and maybe a few of them tomorrow. And so it's very troubling to me that that this standard, this sheet of paper, it seems very one-dimensional, and it doesn't seem to really recognize what we as citizens expect these officers to do for us, let alone their own personal safety, which to some extent is, well, that's what they signed up for. But that's, as a citizen, that's not what I signed up for. So I wonder if you could speak a little bit to how someone who, even the board-certified orthopedic specialist says, cannot squat even 3/4 of the way down to grab someone or pull them or look under a car or do those routine activities, not the extraordinary fighting with armed felons, which is just beyond what most of us could even imagine having to do. But that kind of routine work that we see highway patrol officers out in traffic doing all the time, removing things from the road, checking under vehicles, those type of things, if you can't even bend down all the way.
Thank you. The issue here is that the physicians who testified, the 2 physicians who testified on behalf of Officer Patton, did not present evidence that established she couldn't do them in the mind of the administrative law judge and from the evidence that is contained within the transcript. The rebuttal to that, the independent medical examiner's testimony, was that she actually can perform each of those tasks. There may be some things she has to do in substitution. She may have to lean over more than she squats over, but that she can perform all of those tasks. The law is quite clear from Mansberger and Hosford that the fact that something is difficult, or even that it's dangerous, that it's difficult for them to perform, or that performing them may mean that you're in risk of being injured, those are sort of always present risks in these type of jobs, and they do not mean that she is disabled if there is discomfort. They specifically address things that are not comfortable or are dangerous, are insufficient to find incapacity to perform those tasks. The testimony from the independent medical examiner, which is actually only significant if there had been testimony earlier that the court found showed she was incapacitated, which there was not. The testimony from the independent medical examiner was that she could perform the tasks. Contrary to what has been said here, the judge did not throw anybody off the stand. The judge admonished counsel that non-doctors couldn't give competent medical examination, competent medical evidence as to capacity. We had doctors who gave medical testimony, and then there was an attempt to get medical abilities from the officers, and the court said that that was not allowed, that those officers could only testify as to what their job duties were. And when that became repetitive, the judge said we were done with the testimony on what those 14 critical, well-established tasks are. And in this case, it was established by the medical evidence that she could perform those duties. I understand that everybody would like the most competent people to do it, and the findings of competency are medical. And in this case, the finding was that she was competent and able to perform the 14 critical tasks.
Yeah, I guess my concern is that, and I went through the 600 and some pages that were presented to us, and it seemed, and I know this is your job, but to try to cast these things in a way that didn't seem perfectly clear from, for example, Dr. Shin, in the transcripts I read, seemed to clearly say, in my medical, she cannot do these things. He didn't say it was a psychological condition. He tried to explain, to some extent, some of these sensory motor conditions that go along with chronic pain conditions. But when it comes right back to whether someone who cannot bend all the way down, again, I would say if an officer was being considered for selection and they said, well, I can't really bend down all the way, but maybe I can twist, maybe if I'm having to do it in an opportunity that would allow me to do some really interesting and different approaches than bending down and grabbing and pulling Mr. Miller out of his burning car, maybe I could kind of lean to the side and twist real weird and do things that a regular uninjured officer wouldn't have to do. It just, I have a hard time understanding in this business with the frequency. I think that's, my understanding was what those officers were intended to testify about was, is it realistic the way those 14 critical tasks are explained, and this how frequency, nobody says anything about the frequency or whether you might have to sprint, not run, but slowly after a suspect, or up an embankment and over a barricade. It just seems like a very constricted way to look at things that, and who knows, maybe that's something that needs to be fixed in the long run in a different forum, but
Do you have
it
a
just didn't
question,
make
Mr. Miller?
sense. So could you, what I'm asking is, how do you kind of balance that out in terms of what's really required of an officer to do the job? It just doesn't seem credible that anyone could come to the conclusion that someone who can't even, and it doesn't seem to be any argument that the officer cannot bend, cannot squat down, could do all those tasks on a repetitive basis without some kind of very strange kinesthetic, modifications to the way they do their job.
It's my understanding from being at the hearing and then reviewing the transcript several times that Dr. Henriksen did testify that she could do the tasks at hand, and that the testimony of Dr. Shin was what we call prophylactic, that there were risks, and those risks had effects on her desire and ability, her thought process when she no longer wanted to undertake them. That caused a fear of these risks that she didn't feel when she first entered this job. And having changed her mind about, consciously or subconsciously, about the desire to take on those risks, that does not create an incapacity that is due to a medical condition that would give her a right to an early retirement through the industrial disability retirement process. You're right. People who are 20 are probably always faster runners and better squatters than people who are at retirement age of 50. And perhaps someone needs to think about those changes. And yet, if they are able to perform the 14 critical tasks, which we have testimony here, the competent testimony is that she is, then it is our duty to follow that standard under the law and allow them to return to work. Whether this is an employer stating that an employee should no longer be allowed to work because he or she is slower or overweight or has been injured or is a gender that has less capacity with the size of the person they're combating, those are not the relevant standards. The relevant standard here is medical capacity. And I think the testimony, the specific testimony of the competent medical specialist who testified does not indicate anything other than a prophylactic restriction on her work. And if she is restricted only due to risk, which is the tenor of his testimony from, I think, about page 85 through 95, then that is not sufficient to retire her. If it were, then everybody who starts to get nervous performing tasks that they like to perform 20 years ago, 30 years ago, would be eligible for a disability retirement, and that's not what we want in this situation. It's not the reliable or fair way to make a determination of disability in the ways that we have previously, we and the courts of appeal have previously seen as the standard for disability retirement.
Thank you, Ms. Rodriguez.
Final question there is, when you talk about that, it seemed like that really was a line of questioning that you followed, but that Dr. Shin consistently said she's not capable of doing those things. But beyond that, there would also be this expectation that those could cause further damage or harm. But I guess, do you not recognize that there was an element of a clear medical opinion that she could not do that, though was not capable of performing those tasks, and that it wasn't simply a matter of an aversion to doing them, that there were medical reasons. Motor dysfunctions are not a psychological choice with chronic pain conditions. And on a number of those tasks, all the medical experts that I saw in any of the transcripts, with the exception of the independent medical examiner, indicated that there was a lack of capability to do those things, not an aversion. And even the independent medical examiner had documented that the person could not bend all the way down, for example. Those are things that relate to an actual capacity. So were those all just discounted?
They were neither discounted by me nor were they discounted by the administrative law judge, who had all of these documents in front of him when he made this determination. And the primary issue here is risk aversion versus actual injury. And for whatever reason that risk aversion arises, that was, in my opinion, and in the administrative law judge's opinion, the tenor of the expert testimony, that it was risk aversion risks that had always been there, risks that every officer in the field takes every day. An officer with or without injury can be seriously injured at any time in the difficult and dangerous work that they do. And the fact that someone has a harder time squatting at different times in their life and is at risk for further injury is, by case law and rulings, not the consideration that we use to make a decision of competent medical support for the incapacity. I understand that it's compelling that someone has had injuries and that bodies change over years and are no longer the same as they were originally, but that doesn't mean that they cannot perform the duties of their job, and without substantial incapacity as determined by medical evidence, as the administrative law judge found, we enter a new field of danger for sustaining civil service positions if we go upon prophylactic concerns of possible future risks. And those contain many different kinds of dangers for civil servants to lose their jobs because they're not the perfect specimen they might have been at one time.
May I respond just briefly?
Yeah, please.
Okay, first of all, risk aversion is, right now, that term is really upsetting my client because she's proved she's not risk averse. The loss of motor control wisdom was specifically as to jumping. The only prophylactic restriction given on any portion of her body was her neck only, where the disc replacement is by Dr. Fetter. And finally, the ALJ did not, and you saw the transcript, he wouldn't even consider Dr. Richmond. You know, it kind of makes me feel like that old Paul Newman movie, The Verdict. He's a doctor, isn't he? He's the one who did the EMG. S1 radiculopathy is a nerve issue. We have nerves in our back. So I don't understand why counsel keeps saying everything's prophylactic. It is not. That is just wrong.
Thank you. You concluded, Mr. Miller?
Yes.
Thank you. Ms. Taylor.
Thank you. So I had a couple of questions here. Dr. Henriksen, and I'm sorry, I've forgotten your name.
Cynthia Rodriguez.
Cynthia Rodriguez. I am so sorry, Cynthia.
No problem.
One of the things that stuck out in something that was said is that Dr. Henriksen basically stated that a 25-pound gun belt is supportive and that isn't an additional drag on somebody who has a back injury. Is that true? Is that something that was in, I was looking through it, I was trying to find it, I couldn't find it.
He did say that studies that he had reviewed stated that, and in some cases, and not just police work, but also, I'm sorry, I can't think of an example, but people who wore a work belt with tools on it for construction type, et cetera, right, that were as or more heavy than these. Some of them found the strapping of the belt around them to be actually a support for their back as opposed to a drag on them.
So you are aware, and I'm sorry to interrupt you, you are aware that in, I believe it is in even state labor code that wearing a gun belt for any long period of time is considered a done deal when it comes to a back injury?
Yes, I don't think what he was saying was that she ought to be happy to wear a gun belt. He was actually citing to studies upon questioning about didn't that mean she was going to be worse off. He said some people find it makes you worse and some people don't, and he actually was citing to a specific review.
So based on that that itself doesn't go along with law that's already settled, but in any event, I had a couple of other questions. There was, you had said something about an insufficient argument about meeting the standards, but I was reading through Dr. Richmond's and Dr. Shin's arguments, and that in each and every question of whether she could perform the duties, it wasn't prophylactic, it was, can she perform the duties now? And their answers were no. And I'm unclear as to how that doesn't meet the standards.
I think what Councilman Officer Patton referred to is the answer to that, and that is that when Dr. Richmond was testifying, he was not testifying to his findings. He was testifying to findings of the orthopedist and to Dr. Fetter and to other doctors, which were hearsay, bringing in information from other physicians. His issues, his neurologic, the issues that he addressed, he did not find incapacitating. His testimony was about findings of other doctors. That's hearsay testimony, and it's not supported or sufficient upon which to make a decision.
That's not what I was reading here, though. That is not what I was reading here at all. The questions were directed, can she perform this duty? He said no.
I don't want to be too hair splitting, but actually, again, as I said in my earlier statement, the issue here is why he said no, just as why Dr. Shin said no. He said no, he testifies because of reports he read of other doctors, not his own examination, reports he read of doctors who had findings. He did not have findings in his area of expertise that showed disability. He had to rely on other areas of expertise to talk about disability. When asked, is she disabled, he answers yes, but then when it's explained where that comes from, it's not from his findings, it's from other doctors.
Okay.
And Dr. Shen...
So you don't think that a doctor, a certified neurologist, is qualified to read reports and study the patient as well and make a declaration?
I think he's qualified to do his exam and to come to opinions, but when he states that the opinions, and we have to follow the law, when he states his opinions only come from other people and not from his own findings, his neurologic findings, because he states his neurologic findings do not make her incapacitated. His findings about dizziness or headaches are not the reasons for her incapacity. Only when he looks at other doctors' findings does he see incapacity. And Dr. Shen specifically also says, oh yes, she's disabled. Only on cross-examination does he explain why he thinks she's disabled, and he thinks she's disabled because he believes it's medically unsafe to do things that are risky, and that is not the standard.
That's not what it said.
Please don't interrupt. Please let her finish her reply.
I can only refer you to, those are areas I've read several times, as did the administrative law judge, and I do believe that that is the correct interpretation of their testimony, and it's the interpretation that is explained at length in the proposed decision. Because it's possible to separate the two. Do you think this person's incapacitated? And why do you think this person's incapacitated? When you hear stories of people being in accidents or having surgeries, it can also often be compelling to believe this person couldn't possibly perform jobs, and yet so many of us have been through that, have had significant medical events, and just as Officer Patton, gone on to work 15, 20, 30 years without being disabled. Significant medical events, luckily, are often survivable and recoverable, and having had medical findings previously is not a finding that you cannot do things. Dr. Henrichsen is looking, the orthopedic surgeon, these are orthopedic issues. He's looking specifically at orthopedic capacities that come from the testing that he did, and he finds that she is capable in those specific areas. I think it's very possible for a doctor to look at and learn much from other doctors' statements, but that doesn't make them their competent medical opinion. We have doctors all the time who would like to reflect on other issues, but always we want them to testify in their area of expertise. We use board-certified physicians in their area of expertise and in the injuries that people claim, so that we can have the specific understanding of how that particular issue works in capacity to perform job duties.
So two things I will say. One is Dr. Henrichsen is doing the thing that you are claiming her doctors can't do, which is reading reports and making, and yes, he had his own review as well, just like Dr. Richards did, but making a declaration on those reports that he's reading. So that's number one. But number two, my other question is, Dr. Richard Fetter, who is the orthopedic surgeon, right, wrote in his July 3rd, 2017 report, with regard to lower back, the patient is limited to light work. She cannot resume her pre-injury occupation as a motorcycle officer with the CHP. Dr. Fetter found her objectively unable to perform her duties. Dr. Fetter reported that Ms. Patton cannot resume her pre-injury occupation with the CHP primarily, I'm sorry you guys, I have allergies today, primarily because of her lower back. She cannot wear the Sam Brown belt and use the bulletproof vest, and she cannot do the lifting, carrying, pushing, pulling required to perform the duties of a highway patrol officer. So my question to you is, that was entered into the court, into the testimony, and I don't understand why it was not allowed. It seemed like it wasn't allowed. I mean, it's here, but it seemed like it was discounted. So I was wondering how come that happened.
We do follow the rules of the Administrative Procedures Act, which says that testimony, that evidence not presented in court is hearsay. I will point to page 1504 of Dr. Fetter's, of your document. I'm sorry.
I don't have 1504.
Use your microphone, please, Ms.
It's Respondent's Exhibit D, page 23 of 39, in which at the bottom, Dr. Fetter states clearly, work restrictions with regard to the cervical spine on a prophylactic basis limit the patient from repetitive or other work. So even Dr. Fetter's report, which is not as direct evidence, but which is what Dr. Richmond testifies to, admits that these restrictions are prophylactic. And in this case, that is insufficient. Dr. Henriksen not only did a review of other reports, doctors do consider other reports in coming to their opinion, but their opinion is based on their examination. In other words, a doctor wouldn't simply read other reports, they would do an examination. He did testing, measurements, looked at objective findings that he did himself to determine that she was capable of making the movements necessary and performing the physical tasks that are required in the law for a CHP officer.
So I appreciate all of that, and I couldn't turn to it fast enough. But I question objectivity when a doctor says that a 25-pound gun belt is supportive. But I would like to hear.
If I could just answer that again. That was brought up on cross-examination when he was asked about a gun belt and the various issues with it, and he referred to a study. He did not suggest in his exam or in his direct testimony that people should wear a gun belt for support. He was talking about the various studies and what they have shown about gun belts in response to that question.
All right, thank you. Can I have some response?
Sure. Thank you very much, by the way. The prophylactic restriction was solely on her neck. Read Dr. Fetter's report. I think you nailed it quite well. Dr. Henriksen said some people find, I'm giving you a direct quote from memory, a gun belt supportive. He also, what he was testifying to is he saw no studies and no literature anywhere saying that a gun belt would be causing these low back problems. Denise Patton didn't file for the gun belt presumption, and that gun belt presumption was not given to the CHP members by the legislature for fun and giggles.
Right.
It's based on, I don't have the studies. I mean, if I need to find them, I need to find them, but it was years of studies. And the Peace Officer Research Council and the National Peace Officers Association, they have all of that. I mean, really? Is there somebody here with a gun belt that, we could all put it on and kneel down? I'd love to do that. We do that in front of juries sometimes. Thank you. I think you nailed it. But
Thank you.
Thank you.
Mr. Gillihan.
Thank you, Madam President.
I would just like to say, as the employer, state employees, on behalf of the governor, I get to spend a fair amount of time with the CHP at the academy, at graduations, at the memorial services every year, and sadly last year at the funeral for Officer Lucas Shalou, who was killed in a motorcycle wreck on patrol in South Sac. So a tremendous amount of respect and a deep appreciation for the work you do. My question had to do with the options letter the department provided Ms. Patton, and could you tell us what those options were that the department offered Ms. Patton?
The options letter says something to the effect of you can file for industrial disability retirement if you can no longer do this job. You can request us to file for it. You can go find some other state job, that kind of thing.
So the department did not dispute her injuries?
No, they're not disputing them at all. As a matter of fact, in 2010, after the 1/29/2010 accident, she got. No, they didn't send her an options letter. They came over to her house and they took her badge and her gun. She testified to that in the hearing because they thought she was going to have to go. And what it was is there was some confusion about some things that, I don't know if it was Dr. Richmond or Dr. Fetter had written, which resulted in a reversal of, or clarification. So she was back on the road. And as you said, bravely assuming all risks. And yes, and I've been to a lot of those funerals too, sir. But no, the options letter, she is entitled, if you find that she is in fact disabled from performing these critical tasks, and she can't just do something 1 to 3 times per month. You have demonstrations here. What if you have to drag them out? And you have 100 officers and you have 5,000 people. How many are they going to drag out? That kind of thing. But if she is disabled from doing this job, then she is entitled under 2268 of the Vehicle Code to an industrial disability retirement. And what she does that will comport with her current injuries thereafter is something else. She's not supposed to go and, I'll go be a DMV clerk. Not that there's anything wrong with being a DMV clerk, but that's essentially what the options letter says. Is these other alternatives.
I'm sorry, can I respond briefly to that?
Please.
The reference to the gun and badge incidents is a completely unrelated 2010 incident. The issue of the option letters, after she filed a workers' compensation claim and did not return to work, CHP informed her that if she was not going to return to work, she had several options. She could file for disability, she could retire, whatever options were checked in a form letter. That's not evidence that the CHP believed she should be off work. CalPERS determination is to medical competence, and if if Officer Patton is returned to work, CHP is entitled to conduct its own review of her capacity to perform different things that she may or may not be required to do, and then there is an entire legal process for her to respond to that and to be given opportunities to take several options that exist. This is not the place where we would make a determination as to response to whether or not California Highway Patrol institutes some line of questioning about her capacity.
Okay, thank you. Mr.
For the record, ma'am, she was 14 and a half, 15 months before she got that letter.
Okay, thank you. Mr. Layton.
Thank you. And thank you for your service. This seems to be somewhat of an argument about doctors. I played a doctor on TV, but that doesn't mean I am a doctor. So I want to come back to Dr. Richmond, and out of your testimony, I want a reaction from CalPERS staff. Dr. Richmond is board certified in neurology, peripheral nerve disorders, and spine disorders. So I thought I heard staff say that he merely relied on other examinations, and that's not what I read in the case presented. That he saw her in May of 2017, and that he discussed primary complaints, and then he testified that he examined her and performed an electrodiagnostic study. I don't know what that is, but I presume it has to do with things hurt and nerves don't work right. So I want to hear from staff, did he examine her or did he not? Is this testimony truthful that I see here, that he examined her? And if so, then than his conclusions that she could not perform the tasks. So can you explain to me, am I reading it incorrectly?
We are not challenging the idea that the fact that he examined her or that he performed that, I believe it's called EMG test. As a matter of fact, he specifically refers to that test and saying, and as does Dr. Henrichsen, and I believe also Dr. Shin, in saying that that test did not establish incapacity. When he goes on to talk about her incapacity, he refers to her orthopedic condition as the incapacity. He has a right to review all those records. All that we're saying is that his review specifically, and I'm sorry I can't locate the lines where he specifically talks about it, but the neurologic condition was not what made her incapacitated. But it's not a question of whether or not he examined her. We will have sometimes a physician who will come in and, they spend some amount of time with a patient and say, well, her orthopedic condition is fine, but she certainly seems to have a psychiatric problem. And the answer is, well, perhaps a conversation demonstrates that, but an orthopedic surgeon is not necessarily qualified to make a judgment on a psychiatric problem. So the fact that this neurologist is finding that she doesn't have a neurologic problem, but that he trusts a lot of Dr. Fetter's reports to tell him that she does have an orthopedic problem is sort of a mix of hearsay on the orthopedic issue, because he's taking it from another person who's not in court, who cannot be cross-examined, and who therefore is presenting hearsay testimony. And his own examination, which, as he says at one point, my recollection is about the symptoms that she came in as to vertigo, dizziness, those issues, did not lead to a finding of substantial incapacity.
So, I come from a family that sees orthopods regularly for knees and all sorts of conditions. I don't think orthopedic doctors really work on nerve issues so much as it is bone and connective tissue issues. So, again, I read Dr. Richmond saying his nerve study resulted in positive findings at the S1 nerve root. And then he discussed the 14 critical tasks and opined on her ability or inability to perform those tasks. So I'm a little confused because I see a board-certified doctor saying there's nerve damage and then opining on the ability to do tasks. So what am I missing from this? What am I not seeing?
Again, I mean, I can look for the testimony, but...
This is on Respondent's Argument, page 9 of 20.
Oh, and I'm sorry, I'm looking actually in the transcript around page 125, which is where he testifies to what he found. And it's my recollection that he first testifies about his examination, and then he later talks about her capacity, but he does not link her capacity to his neurologic findings. Instead, he links them to other physicians' findings. I believe he actually found that he states at some point that the neurologic test and neurologic finding is not the one that demonstrates incapacity.
All right. Let me ask you a bit of a different question. You mentioned earlier, you talked about, and you used two terms, desire and ability to do the job. And you were differentiating between those two things. And again, we've been talking about prophylactic and fear of additional injury. First of all, let me ask you this question. Is a mental condition medical?
A mental condition can be medical.
Okay. So
fearing things that everyone may fear, dangerous or risky things to do, is not indicative of a medical condition.
I understand. So let me go beyond the issue of fear. If I've had a diagnosis that tells me if I do X, Y will occur, not the fear that Y will occur, but it will occur, and I've gotten medical advice that will occur. If I do this task, I will suffer an injury. Is that different than the fear of the possibility of an injury?
Fairly philosophical question, but yes, I think it is different because this is, they're not saying if you do this activity, you will have this injury. The prophylactic restriction is the risk of a injury, and that risk, not the certainty of it, but the risk, that has always been there. And, if we did studies on safety versus non-safety employees, we would probably find that safety employees have less of a fear of risks. But if you develop a fear of risks that normal people always have, that's one of the regular human options, to be afraid to jump off the high dive as opposed to being willing happily to jump off the high dive. That's not an indication of a medical problem. It's just an indication of a tolerance, and your tolerance can always change.
Okay.
That's not a mental insufficiency or...
All right, last question. The ability to go get another job. And again, I'm not that familiar with state service and how the rules work. But if you go to work for the CHP and you now are told you cannot do the job that you were hired to do, are you... I guess if there's no other job that you can do in the CHP, in the whatever ranking you have, then you are forced then to go to retire, forced to go outside. I mean, I thought the issue of disability dealt with you cannot do the job that you are hired to do.
I don't think that the findings, certainly not the findings that we presented, nor the finding of the administrative law judge, was that she could not do the job. She no longer is willing to take those risks, and whether that's a physical or a conscious decision, or just she's no longer that person who can do those risks. The CHP would be able to make that determination and see if they had other jobs. And there are certainly, it's not a matter of she's being turfed out by us at all. She's able to go back to the CHP, and a new set of decisions will be made there, available jobs, et cetera. Emphasis on, CHP has no light duty, CHP has no ability to do this or that. That's actually not a finding that we make here, and it's not a consideration. If she is not medically incapacitated, then she goes back to CHP, and they make decisions there. And they may have jobs for her, they may not. That's not amongst the considerations that we address. But certainly, we are not saying that someone who is found to have a medical condition that means they cannot do their work, not a change of perspective on risk-taking, we don't make them leave. They can choose to leave if they don't want to. Certainly, we see this regularly in safety jobs, in regular jobs, correctional officers who no longer wish to take those risks with their life, who see other things happen. Safety officers, people who work at Park and Rec, any type of job, they may decide that the qualities of danger or comfort level or whatever at their job are not for them. And that is a decision they can make. And when they make that decision, if the outcome of it is that they're going to leave their employment, that's their right to do.
Okay, thank you.
Thank you. I just want to ask, you were looking for a spot in the testimony where Dr. Richmond referred to Dr. Fetter's report. Are you looking for page 132, 133? I think that's where he says he was referring to Dr. Fetter's prior report, I believe.
Luckily, we have a wealth of medical testimony in this case.
Indeed.
Yes, he does refer specifically to Dr. Fetter's report on those pages and the findings that he believes from having reviewed those reports. Thank you.
Okay, Mr. Fechner.
Thank you, Madam Chair. First of all, I want to thank you for your service. But upon reading the ALJ's decision, and especially paying attention to our independent counsel's complete review of the case, I move that the board adopt the proposed decision as its own in its entirety.
There's the motion. Is there a second to the motion? Motion. Sorry, a motion and seconded by, I'm sorry, Mr. Rubalcava. So that is the motion on the table. On the motion, Mr. Miller.
Back to me to speak?
Back to you to speak, but on the
Okay.
motion.
Oh, on the motion?
On the motion. Now there's a motion before us.
Yeah, I'm opposed to the motion. I feel that there's still real unanswered questions in my mind. I feel that there's this, kind of as Mr. Slayton referred to, this battle of the expertise, and it's sounding more to me like a lot of this hinges upon someone putting orthopedic ahead of the real issue of the neurological symptoms. And I'm very concerned and, almost offended a little bit that something like a motor dysfunction as a result of chronic pain, which is a real physical organic condition that is medical and is not a matter of choice or a decision of the patient to be risk averse. I mean, that keeps coming up as that's the interpretation here, and that's not what the testimony of Dr. Sheehan or anyone else would lead me to believe, having looked at it and read it. Is a concern that really makes me unwilling to support that decision.
So I think your options would be to move a substitute motion either with a different determination or for the board to go into closed session to further deliberate and then come back with a decision. Those are two options before you.
Yeah, I would move we go in there because I'd like to further explore exactly the implications of the options we have before us, and also in the light of the respondents.
So the motion is to recess into closed session to further deliberate. Okay. Motion's made and seconded. Any discussion on the motion? I'm sorry, the seconder was Mr. Gillihan. Any discussion on the motion? I have a few requests to speak. Are those on the motion? Okay. All those in favor?
Aye.
All those opposed? Motion passes. We will now recess to deliberate in closed session.